Well, welcome to the last session of the fourth day of the 18th International Conference in memory of Marco Biagi, and a warm greeting to everybody, friends, colleagues, scholars, and local authorities. My name is Francesco Basenghi. I'm a full professor in the University of Modena and Reggio Emilia, and I work in Marco Biagi Foundation as well. So before giving the floor to the speakers of this last session, I would like to congratulate you on the very high quality of the contributions. On the other hand, the success of this conference is also demonstrated by the large number of accesses that were registered not only in the opening day, but also during the other days of the conference. From what emerged during the conference, in my opinion, we have drawn confirmation of at least two phenomena. In the first place, there was a confirmation of the growing relevance of a team that emerges with strength in the various national legal system, obviously in a different way according to the different sensibilities of each system. It's about a strong need to take note of the inadequacy of the traditional distinction between self-employment and subordinate work, which is no longer adequate to read the complexity of the reality, represented by an increasing vast series of work organization models. In this slide, there is no doubt that the reflections expressed during this conference are really important. Secondly, as the reflection of the first phenomenon, there is an increasing need to articulate in a new way the protection that historically characterized labor law, which is understood as a regulatory system intended to protect subordinate work. In this key, weak work no longer coincides with the area of dependent work and must be extended to the larger areas of non-subordinate work. In this regard, I believe it's important to cite the words written 20 years ago, but extremely actual. Following the profound changes that have taken place in the organization of relations and labor markets, the traditional regulatory approach, which opposes dependent work to self-employment, work in a large company to a work in a smaller one, a protected work to the non-protected one, seems to be outdated. It's rather true that some fundamental rights must be applied beyond their legal qualification to all forms of work rendered in favor of third parties. Think of the right to the protection of health and safety conditions in the workplace, to the protection of freedom and dignity of the worker, the abolition of child labor, the elimination of all forms of discrimination in access to work, the right to fair compensation, the right to protection of personal data, the right to trade union freedom. This binding core of fundamental rights must form the basis of a modern labor statute. We all know when and who wrote these words. It was in 2001 by Marco Biagi, who with extraordinary foresight anticipated issues that are still relevant today. This is his priceless cultural legacy. But I don't want to take away any more time, and after renewing my congratulations for the excellent work done so far, I leave the floor to the speakers, and in particular to the first speaker of the afternoon. So, Ylenia Curzi, University of Modena, Reggio Emilia.
Thank you, Professor Basenghi. Can you hear me? Yes?
Yes.
Okay, yes. Thank you. Thank you. I would like, first of all, to thank all the Marco Biagi Foundation for this opportunity to contribute to the discussion, the conference. And in this brief speech, I would like to try to address the key issue of autonomy at work, both within and outside the employment relationship, from an organizational perspective, because my field of study is indeed the field of organizational studies. So I would like to start with a very brief background. Autonomy at work has always been a key issue in the organizational debate, at least since the late 50s of the last century. And today, the digital transformation of work seems to give new momentum to this debate. Indeed, within the organizational field, we can identify at least two main opposite and predominant position or theses. On the one hand, the thesis that the digitalization is leading to a new digital Taylorism, thus boosting subordination and standardization of work, both within and outside the employment relationship, and on the other hand, the position that, in contrast, the digital transformation of work would lead to greater workers' autonomy, both within and outside the employment relationship. The available empirical evidence is not enough, is still insufficient. In any case, some preliminary analysis of some proxy variables that can be drawn from the last publicly available European Working Conditions Survey suggests that we can exclude that, at least in Europe, smart factories or smart companies are increasingly converging towards this model of new digital Tayloristic mode of production and work organization. So it seems that experience-based knowledge still continue to be relevant also in highly formalized, highly digitalized work processes, both within and outside the employment relationship. Despite this preliminary evidence, however, as organizational scholars, we cannot conclude definitely that the greater relevance of human judgment in a highly digitalized work is related to greater workers' autonomy. We cannot conclude this, basically because, on the one hand, empirical evidence is not enough to support this definitive conclusion, and on the other hand, because several studies, empirical work in the field of organization studies do not clarify what they mean by autonomy, do not provide a clear definition of the concept of autonomy, and do not clarify the different aspects of work over which autonomy can be exercised. At the same time, and on the other hand, it seems that the preliminary evidence is also contributing to foster a debate among other fields, among labor law scholars, and to foster the critical reflections among the autonomy subordination divide. Because on the one hand, within the employment relationship, we see workers that are less and less subject to strict hetero direction. In Europe, an increasing number of formally subordinated workers can choose when, how, and where to perform their work. On the other hand, in the realm, for example, of platform work, at least formally self-employed workers are increasingly working using digital platforms, the operational logic of which is a black box for them. So they are not able to completely understand the operational logic of such platforms. They are not able to influence the operational logic of the platform. So it seems that autonomy at work, both within and outside the employment relationship, is a field of investigation that is of interest of different disciplinary fields. And so it is a field of investigation that opens up the opportunity for a challenging and interesting multidisciplinary analysis. So in this speech, I would like to highlight some organizational concepts that can be useful for this multidisciplinary organizational analysis, multidisciplinary analysis. When selecting the concepts drawn from the field of organizational studies, I operated in a selective way. That is, I only selected concepts drawn from theories about the organization that share a common processual point of view. That is, I only draw concepts from organizational theories that consider the organization as a process of actions and decisions guided by bounded and intentional rationality, and theories that consider the organization, the structure of the organization, as a conscious process of coordination of work activities that are aimed at a common organizational goal, but also a conscious process of coordination that try to keep together different values, not only efficiency, but also other values such as people's well-being at work. So given these premises, I would like to start with the concept of autonomy. And in this regard, I would like to remember the distinction put forward by Bruno Maggi in 2003, the analytic distinction between autonomy and discretion. According to Maggi, autonomy is the ability to produce one's own rules for the self-governance of the processes in which one is involved. In contrast, discretion refers to room for maneuver in a process which is just pre-regulated. Within this process, agents have only the possibility to choose among a set of predefined alternative courses of actions and decisions, and they have not the possibility to take into consideration additional or different alternative courses of actions and decisions. According to Biagi and according to other scholars that have followed this stream of research, autonomy can and should be analyzed at different levels of analysis. And for the purpose of this speech, I will consider three main levels of analysis. The micro level of analysis, which is the level of the job, the work situation that most immediately concern each single individual agent or a collective of individual agents. Then we have the meso level of analysis, which is the level of the formal of organization as a whole, where a dominant coalition is responsible to make the most important decisions about the key components of the organization as a whole. For example, the wider organizational goals, the structure, so the configuration of all work processes within the organization, systems and criteria for allocating resources and for evaluating performance at any level. All these decisions are made by the dominant coalition at the meso level of analysis and have implications for efficiency, for people's well-being at work, for inclusion, for integration, and so on. Then, at the macro level of analysis, we have the relationship between the formal organization as a whole and its environment. So Maggi said that at any level of analysis, autonomy and heteronomy are simultaneously present, because there is no an organizational process which is completely autonomous, and there is no an organizational process which is completely heteronomous. This means that within the employment relationship, autonomy and subordination, or autonomy and heteronomy, can be simultaneously present, at least from an organizational perspective. To clarify this point, I would like to follow the suggestion put forward by Aloisi in his paper presented in the first workshop of this conference. The suggestion is to look at the definition of employment relationship and employment contract put forward by Simon in 1951. Simon, in this paper, says that the employment relationship is basically a relationship of authority. Through the employment relationship, the employee accepts the employer authority. Following Barnard, Simon shared the idea that authority is a sort of bottom-up process. So employee enter the contract, the employment contract, and accepts that the employer decisions, the employer's rules will guide his behavior. In his work titled Administrative Behavior, Simon states that the authority relationship is a relationship of subordination, because the employee accepts that others' decisions, other rules, will guide his behavior. Such a decision, however, can take different forms, and not necessarily the authority relationship will find expression in strict rules of execution and close monitoring of job performance. To explain this point, once again, I would like to follow one suggestion coming from the conference and consider what Simon stated about the employment relationship and employment contract. Simon, in the 1951 paper, says that the employment contract is a powerful means for coordination, for planning under uncertain conditions. And in order to develop further this idea, I would like to introduce two different dimensions of uncertainty. Following Simon, Thompson in 1967 suggested that there are two main dimensions of uncertainty. The first concern the expected results. The other dimensions of uncertainty concern the means to achieve the expected results. More precisely, it concerns the knowledge about the means and relationships. So by combining these two dimensions, we can identify 4 different situations, and in 2013, a colleague, Albano, suggested that at the micro level of analysis, so at the level of the job, of the work situation, which most immediately involves the individual agents, these 4 situations are related to 4 different ways of organizing and coordinating the employees' contributions. In the first situation, when both means and ends are certain, coordination can take place through the close monitoring of job performance by the employees. Coordination can take place through strict rules that workers are expected to execute without any deviation. This is a standardization of the way of executing the work. In the second condition, objectives, expected results are certain, but the means are uncertain. So coordination can take place through the standardization of professional competencies. In this situation, workers can exercise only discretion, and in this situation, performance management systems, as we know them, can play a key role for standardizing competencies so as to ensure the achievement of preset goals. Then we have the third and the fourth situation, the situation in which the expected results are uncertain and the means are certain, and the situation in which both means and ends are uncertain. In these last 2 situations, coordination takes place through modes of coordination that allow workers to exercise their autonomy. So autonomous rules in the strict sense, so in line with the definition of autonomy put forward by Maggi, autonomous rules are developed within a collective of workers through cooperation, through conflict. The development of autonomous rules allow workers to develop organizational knowledge, to improve work process effectiveness, and this development of new competencies and of new knowledge could be a source of reputation for them. In any case, the main point of this analysis is that at the macro level of analysis, we can have more complex situations in which work is organized in a way that allows the workers to exercise autonomy, but such ways of coordinating work, like the other one, the standardization of competencies and the standardization of way of executing work, may be the result of decisions taken at a higher level of analysis, the meso level of analysis. So decisions that can remain in the hands of the dominant coalition, decisions that the workers are not able to affect or accept not to affect. So in the more complex situations, we can see that workers continue to be subordinated, continue to be subject to heteronomous rules, even if they are able to exercise autonomy when they perform their work. So autonomy and heteronomy, autonomy and subordination are simultaneously present at the micro level of analysis, and because of the continuing presence of this heteronomy, the simultaneous presence of heteronomy and autonomy may be the ground for the application of the labor law protections, even if workers exercise autonomy when they perform their work. And in 1948, Simon seems to suggest that these labor law protections can be understood as legal heteronomous rules that limit the freedom of the dominant coalition when they apply the efficiency criterion in order to take their decision, and heteronomous legal rules that force the dominant coalition to take into consideration, besides profit, other values such as inclusion, such as people well-being, such as integration, and so on. So I think, and I'm going to conclude, that this concept, this idea, which refer to the potential ability to affect the key decisions at the meso level of analysis, and this idea that autonomy and heteronomy can be are always simultaneously present at each level of analysis, may be of help also to talk about autonomy, to address autonomy outside the employment relationship. I think that in this respect, we should focus at the meso level of analysis, and at this level of analysis, self-employed workers are expected to be autonomous, so to be able to define in an autonomous way the key decisions about the key components of the organization as a whole. So organizational goals, organizational structure, systems for evaluating performance, and so on. However, autonomy is simultaneously present, also this level of analysis, with heteronomy, because there is not an organization which is completely self-sufficient. So the organization develop relationships with relevant stakeholders in the task environment that can affect its ability to autonomously decide about the key components of the organization. So in assessing whether and to what extent self-employed workers can make autonomous decisions at the meso level of analysis, we should also consider the macro level of analysis, that is the relationship with relevant stakeholders in the environment, and more precisely, we should consider the actual or potential ability of self-employed workers to affect the key decisions of the stakeholders in the environment on which they depend most. So we have to consider the actual or potential ability to exercise control over the stakeholders in the environment in which they depend most, because on this ability depend their ability to be able to self-regulate the actions and decisions in the future. I've concluded.
Thank you, Ylenia, and congratulations for your report. Very exhaustive, inspiring, full of suggestions. And now I leave the floor to Manos Matsaganis. Please, Manos.
Hello, thank you very much. Can you hear me?
Yes, very well.
Very good. I'll just share my my file, I think. Very good. Thank you. Right. This is the title of my presentation. It's a good thing that, as you said, it's an interdisciplinary conference, because I'm an economist, and you know, most of the presenters and and speakers so far have a background in law, so they may find some of the things I say a bit strange or controversial, but let's see how it goes. This is the title of my presentation. I'll briefly discuss stylized facts, false starts, wrong turns, dead ends, and some ideas for a possible way forward. The first point I would like to make is that sometimes we all speak as if all forms of non-standard employment have become more common. This is not quite right. It is certainly correct that standard employment, understood as full-time, open-ended, dependent employment, has declined. That's beyond doubt. But although some forms of non-standard employment have become more prevalent, this is not correct for all of them. For instance, we know that there is more part-time work in Europe, even though there is less part-time work now than there was 6 years ago, 7 years ago. And the same goes for temporary employment. There is more temporary employment around than there was in the 1980s in Europe, but also beyond Europe. But again, it has fallen slightly in recent years. On the other hand, this is certainly, emphatically untrue in the case of self-employment. Have a look at this graph. You see very clearly that the share of self-employment in all employment has fallen in the European Union from 18 to 15% over the last 20 years or so. And in Italy, there has been even a slightly larger fall in recent years. Obviously, there is more self-employment in Italy than there is in Europe as a whole, but it has been falling here too. So self-employment is becoming, if anything, rarer, more rare, not more frequent. And this is true for most countries. I'll show you the few countries in which the self-employment rate has increased over the last 10 years. At the top is the Netherlands. And the Netherlands is an interesting case. There was a report last year, a Bolso report, Bolso Commission report, that concluded that the rise of self-employment in the Netherlands was very much favored by employers, but it has been a rather bad thing for the Netherlands as a whole, both in terms of social protection and also in terms of the dynamism of the economy and the future skills level of the Dutch economy, and so on and so forth. So the Netherlands is a bit of an exception and may be coming to an end, actually, given that it is quite likely that the new government that has emerged from yesterday's general election, this week's general election, is likely to change the labor law and the social security law to make freelance work and other self-employment less attractive to employers. The other countries in which self-employment has become more frequent, we are talking about very little changes. Lithuania, France, less than 1 percentage point. In many, many other European countries, the self-employment rate has fallen quite dramatically over the last 10 years. Look at Portugal, 6 percentage points, or Greece, but also other countries, Slovenia, Poland, and so on and so forth. On the whole, self-employment has become less frequent, no more, not more. And this is equally true outside the EU. With the exceptions of the United Kingdom and New Zealand, elsewhere, the self-employment rate has fallen from rather a low level anyway. Look at the United States, from 7 to 6%. That's a very small share of the workforce. So, nevertheless, the rise of the platform economy and the spread of dependent self-employment have become policy concerns. The challenge for social policy is to close the coverage gaps and reduce in-work poverty, which we know that is higher. This is a very bad table. I doubt that you can see it, but the point is that in-work poverty rates are much lower for standard employees than they are for the self-employed, and also they are lower for the self-employed than they are for non-standard employees. On the whole, the rise in in-work poverty associated with non-standard employment, including self-employment, has made it a policy, has made self-employment a policy concern. Now, I'd like to open a brief parenthesis to say something that I think is relevant. Although I think policy should protect autonomous workers, I don't think policy should encourage autonomous work as such. And sometimes when I read government documents and official proclamations of the European Union, the European Commission, I get the impression that the boundaries between the two things are sometimes blurred. Look at the European Employment Strategy goals from the European Commission's DG Employment website. Self-employment, help and entrepreneurship, help create jobs, develop skills. Well, do they? It's certainly true for entrepreneurship. It's not true for self-employment. There is quite a lot of evidence in economics that there is a key distinction within self-employment and entrepreneurship more broadly between necessity-driven, very frequent in low-income countries and among low-income groups of the population, and opportunity-driven entrepreneurship and self-employment, which is more frequent in advanced countries and among higher skilled groups of people within countries. Now, the thing is that although people say small is beautiful and all that, this is not true. Small firms, on the whole, tend to be less innovative and less successful. The key thing is for new firms to grow, not for small firms to remain small. That's a rather bad policy option, and sometimes public policy may encourage, perversely encourage firms to remain small. That's wrong. There is another thing that makes me believe that public policy should not encourage autonomous work, and it's to do with tax compliance. Now, in my own country, Greece, the share of income from self-employment that has been estimated to be underreported is almost 50%. Now, some of you may think, oh, well, Greece, what do you expect? Corruption, incompetent tax administration? Well, yes, perhaps, but look at the US. Joel Slemrod, who is the most celebrated analyst of public economics in general and tax evasion in particular, has estimated that in the US, the self-employed evade, underreport almost 60% of their earnings. And you know, the US is a country in which Al Capone went to jail and stayed in jail, not because he was a serial killer, but because he evaded taxes. The Internal Revenue Service in the US is characterized by professionalism and integrity. And yet, the extent of tax evasion among the self-employed is greater than it is in Greece, and I'm sure in Italy too. The good thing for the US is that it is only 6% of the population of the workforce that are self-employed, while in Europe it's 18 or whatever, and in Greece and Italy much more. Actually, Greece is the country with the highest share of self-employment in all employment. So for all these reasons, I would be rather skeptical to policy measures that actually provide incentives to people to become self-employed and remain self-employed. I think that would be a bad idea. Now, of course, as I said before, protecting all workers, including obviously the self-employed, is a good idea. The question is how to do it. And here we come to my false starts, wrong turns, dead ends. Let's start very briefly. I'll say a few words about what I consider to be false starts. Remember, well, some of you who have read the great German political economist Fritz Sharp may remember his phrase that sometimes social democratic governments can only introduce socialism within one class, meaning employees. Well, that was a rather common perception throughout Europe in Bismarckian social insurance systems, and that was the case for a long time. Social insurance concerned mostly employees, and as for the self-employed, they were somehow relegated to their own separate systems, except that those separate systems provided lower contributory benefits, for instance, pensions, no entitlement, or not just unemployment benefits, but also sickness and maternity benefits. And sometimes there was an overreach of contributory social insurance into policy areas that are best left to beverage type organization like healthcare or child benefits. Think of assegni familiari in this country, Italy, in which even today are reserved to employees, to some types of farmers, very few, and all pensioners, including pensioners who used to be self-employed, but not the self-employed who are still active. Now, obviously, as most of you know, there is going to be a new type of child benefit which is open to all professional categories, irrespective of whether they are employees or self-employed, and that's a good thing. The idea of having a different social protection system for the self-employed is still common practice in the developing world, in Latin America, for instance, or other continents. But it is an affront to universalist aspirations, and also, from my point of view, almost equally significant, it's utterly ill-suited to a dynamic economy. And I'm going to say a few words about that shortly. Have a look at this table from a publication that we did a few years ago with colleagues. The data are a bit dated, old, the middle of the previous decade, 2014 or 15. As many as 38% of the self-employed in the European Union are at risk of not being entitled to sickness benefits. And among employed women aged 15 to 49, as many as 46%, if they are self-employed, are at risk of not being entitled to maternity benefits. So it's pretty bad. Now, there has been quite a lot of talk in this conference on previous days and today, briefly, about creating unemployment insurance programs for the self-employed. Well, clearly, it's something that can be done. And in fact, many EU countries and European countries outside the EU already do. Some on a compulsory basis, few on a voluntary basis, and there is a number of European countries in which there is no unemployment insurance protection for the self-employed. All right. Well, as an economist, I must confess that I'm quite skeptical to the idea that unemployment insurance is an efficient policy for the self-employed. Well, in my mind, unemployment insurance for the self-employed has one big side effect, and this is that in economics jargon, the decision not to work, which is exogenous in the case of employees, you lose your job because your employer tells you that you are no longer needed. If you are self-employed, it is partly your own decision. That gives rise to the problem of moral hazard, which is one of the problems that undermine the efficiency of insurance in general. There is another consideration that makes me skeptical of unemployment insurance for the self-employed, which is that increasingly the distinction between work and lack of work is not so clear. It's not a binary outcome. It's not even binary for employees. You know, the Cassa Integrazione in this country and Kurzarbeit in Germany and furlough schemes in Britain and elsewhere have protected during COVID, but in Italy and Germany even before, have protected employees who did not lose their job. They were not made fully redundant, but they worked fewer hours, right? So that means you can be an employee, work less, get paid less, and yet still remain in work, right? Well, this is even more common among the self-employed. It is comparatively rare for the self-employed to stop working, in which case unemployment protection might be relevant. And here again, I recall the earlier distinction between necessity-driven and opportunity-driven entrepreneurship. In the case of self-employment, when self-employment is necessity-driven, that means you are self-employed because you cannot think of a better option. You cannot get a dependent employment job as an employee. Your reflex, your reaction when business is failing, when there is less and less demand for the services that you provide, is to remain in activity because you have nothing else to do. On the other hand, when self-employment is opportunity-driven, your reflex when business is failing is to cut your losses, close, and start something else, right? Well, if that's the case, necessity-driven self-employment implies that the workers concerned would be better protected with furlough schemes if they were feasible. And unemployment protection would be more appropriate for opportunity-driven self-employment. Entrepreneurs who see that the business is not going as well as they had hoped, so they just close their business and they start again after a few months. This latter case is still quite rare in Europe because both business culture and bankruptcy law stigmatize failure. For instance, you cannot easily get a loan from your bank to start a new business if you made a mess in the previous business that you started. In the US, it's not like this. I mean, I simplify, but most of the time, banks and law and culture are more, if not supportive of failure, at least tolerant of failure. So unemployment protection is more appropriate only when the self-employed close their business altogether. But most self-employed workers in some parts of Europe, certainly in my country, Greece, but I suspect even in Italy, not among lawyers, but among lower skilled artisans and others, is necessity driven, and then in their case, they remain in activity far too long. And unemployment protection won't do much difference in their lives. What about the dead ends? I heard a presentation, I think it was the day before yesterday, a very interesting one, in which the presenter from Max Planck Institute in Germany discussed at some length the double burden that self-employed workers face in terms of contributions. She's in good company here because the International Labour Office has actually come out in favor of, has called countries to take measures, adapted mechanisms, to stop self-employed workers from paying a double contribution, meaning that in some countries, self-employed workers pay both their own contributions and also the contributions that correspond to an employer, but they don't have an employer, so they pay the entire contribution by themselves. So I imagine, from what I heard, that this is a rather common view, not just among ILO analysts, but also among legal scholars in Europe and elsewhere. Well, as an economist, and I'm afraid as a Greek economist, I have many doubts. I'm not going to go through the history of social insurance for the self-employed in Greece, except to say that until pretty recently, the self-employed in Greece paid flat rate contributions, right? Irrespective of income. But after 5 years, they paid more contributions, and after another 5 years, they paid even more contributions, but still a high earner with 10 years experience paid the same as a low earner with 10 years experience. It was a regressive system. And obviously the Greek social insurance system was very fragmented. In 2016, under pressure from the hated Troika, social insurance in Greece was unified. And in my view, that was a very good thing. And contributions for the self-employed were made income related. And the contribution rate for the self-employed was equal to the sum of employer and employee contributions. Since the self-employed are under pressure in Greece because of the crisis, the long, deep Greek crisis, but also because the self-employed are able and willing also to evade taxes and social contributions, when the social contributions went up, receipts from social contributions fell quite a lot. So it was a disaster. Then came the Constitutional Court that declared the so-called double burden burden unconstitutional. So the previous government said, all right, let the self-employed pay only the employee portion of social insurance contributions, not the employer portion. So they ended up paying 1/3 of what employees and their employers together pay. Then there was a change in government, and the new government abolished the whole idea of income-related contributions for the self-employed and went back to the previous system, very regressive, this time without any adjustment for length of experience, you know. So now it is legal, perfectly legal, for a lawyer or a doctor, you know, even a pretty wealthy doctor or a lawyer or architect or whatever, to pay less than a cleaner or a bricklayer in social contributions. I don't think that's a very good idea. As a matter of fact, regardless of what the Greek Constitutional Court may think, the double burden is quite common in Europe and elsewhere. In the US, for instance, the self-employed pay a contribution rate which is equal to the sum of employee and employer contributions. The same is true in Europe for many countries, the majority of countries. You know, they are listed in this table and also in this table. Actually,
excuse me, Manos. Excuse me.
Yes.
Could you try to conclude in just in 5 minutes, because we have a problem of timing. Thank you very much.
All right. Okay, I will conclude. Just a couple of slides. So, what would be a way forward for social protection? I think the first thing would be to make social protection less contributory. Increase the weight of non-contributory elements in healthcare, childcare, child benefits, basic pensions, and other such instruments. The remaining contributory benefits, I think, should become more actuarial. In other words, benefits should be more closely tied to contributions. And the third point would be that labor taxation should be reduced for all workers, not just the self-employed, but for employees too, shifting the burden away from labor to wealth, businesses, including platforms, and of course, tax havens and loopholes. And with this, I will conclude. Thank you very much for listening.
Thank you, Manos. Thank you for your report. Very, very interesting, and I apologize for the claim. And now the floor to the last speaker, Adalberto Perulli, University of Venice, Foscari. Please, Adalberto.
Francesco, can you hear me?
Sì, ti sento forte. Yes, I hear
okay.
You very well.
Okay, thank you very much, Francesco. Can you see the slide?
Yes.
Okay. Okay, perfect. First of all, let me deeply thank the colleagues and friends of the Marco Biagi Foundation for having me in this conference in commemoration of Marco. Marco was one of the first scholars in Europe and in the world to look beyond employment. As Francesco said before, Marco elaborated a statute of work, providing a regulation for work in general, whether dependent or self-employment. This proposal was not converted into law, but the Italian system has moved in recent years towards an expansive tendency, invading territories outside employment to provide protective regulation for self-employed. Basically, it is the perspective that Marco had proposed. Let me say that having dedicated an international conference of labor lawyers to self-employment is a sign of the time, but it also a sign of courage, because many scholars around the world are still convinced that only guiding star of the system is employment, the employment relationship. Underlying this vision is the idea that subordination, only subordination, expresses the axiological dimension of labor law, while self-employment is unrelated to the protection function of labor law. I would like to put forward a different vision, without denying that labor law has its traditional basis in subordination. I think that labor law is a much broader and more complex field, which must also include self-employment. I would say that the methods for achieving this are different. For example, in Italy, TIZIANO TREU recently proposes a remedial approach. English colleagues, the category of personal work relationship. Other, like me, the category of economic dependence, and so on. But today, I will not address this issue. I will use 4 arguments to support the idea of expanding labor law beyond employment: a sociological argument, an historical argument, an economic argument, a comparative argument. They have, of course, different functions, but they converge in the belief that labor law is currently the law of self-employment and not only that of employees. The sociological argument is the simplest. The sociology has for some time been analyzing the characteristics of the new self-employment, which is defined as a new generation or second generation to distinguish it from traditional self-employment. This second generation independent work is essentially the result of the great processes of outsourcing that characterized the end of the last century, with the transition from Fordism to post-Fordism. Actually, this second generation of self-employment seems to follow a paradigm which goes back to the German sociology of the Weimar period, which in the 20s and 30s analyzed the first phenomenon of self-employment, when large multinational began to use new skills in the fields of marketing, advertising, human relations, public relations, and so on. And these workers were not employees, but self-employed. The sociology of the time of Marxist inspiration provided for a destiny of proletarianization of independent work, that is a substantial inclusion of self-employment within employment. However, what happened later denies this homologation. Today, many second-generation self-employed knowledge workers, intellectual workers claim their condition of independence. They do not want to be employees. Many sociological researches confirm this propensity of the new self-employment and disprove the hypothesis of their homologation, their forced proletarianization. However, this is the most important point, sociological analysis on new generation of self-employment represents a regulatory deficit of social protection, especially for weak, economically dependent self-employed with low and intermittent incomes without social safety nets. And of course, the COVID pandemic has enormously highlighted this lack of social protection for self-employed. Such workers often lack an adequate union or collective representation, and they are far from fully realizing their personality with strong social ties. The
Professor,
historical argument.
Sorry to
Yes?
interrupt. I don't know if you want to go ahead with the slide.
Where? Sorry?
I don't know if you want to also go ahead with the slide. I don't know if because we
yes,
see.
I'm not going on with the slide.
No, if you wish, you can say next, and I will do it for you.
Oh, I'm sorry. I moved my mouse for is this the 5 slide maybe? Argument 1? No.
And Adalberto, you cannot be
I'm
seen.
sorry. I go ahead without the slide. I'm sorry.
Adalberto, the way you move the
Yeah.
slides is different. You have to use those arrows that show underneath the slides, not the way you would normally move it on your computer.
Yes, probably I'm using a bad method for moving the slide. I don't know. I'm sorry.
Why don't
I
you?
don't know if someone can help me in moving the slide.
If you tell Francesco, Francesco will move the slide on.
Exactly. If you want, you say simply next, and I will move it. Right now, I'm at historical argument number 1. Okay.
Okay. Now we okay. Thank you very much, Francesco. We stay here. I'm very sorry for this problem. Historical argument. We are led to believe that labor law was first conceived with subordination, that is, with the creation of the employment contract. But the question is much more complex. Social legislation came before the employment contract and does not only concern those relationships that today we would consider subordinate, but also self-employment relationships. In the continental tradition, the service performed for others has for centuries found its place in the context of the unitary scheme of the locatio et conductio. And in the proto-capitalist Anglo-Saxon world, labor was managed by that kind of labor code represented by the statute of artifices and from the poor law system. These laws were independent, of course, from contractual types and referred both to farmers and to artisans due to the universal obligation to work by all those who were able to work. So for a long time, the legal perception of work reflected all forms of activity in favor of others, which find their basic paradigm in the scheme of the louage d'ouvrage and of the faire quelque chose pour autrui, do something for someone else. Even the regulation of work in common law systems for a long time did not contemplate a clear distinction between employment and self-employment. In England, throughout the 19th century, the scope of labor legislation did not depend on the type of the contract, but on the nature of the work. The legislation on wages, as well as that relating to other matters of the relationship, applied to specific categories of workers, such as agricultural laborers, artificers, colliers, and so on. And the main test adopted by the master and servant law was based on the criterion of the exclusive service, which should have excluded task contracts and causal hiring from the scope of the law. But the courts applied the test with flexibility, verifying the existence of a reciprocal obligation between master and servant to serve and to provide work for a defined period. And this interpretation has allowed groups of professionals with a tradition of independence to gravitate into the scope of labor legislation. The next, please. The next. Okay. In Italy, Ludovico Barassi, in his pioneering volume on the employment contract, states that labor law has a remarkable, unusual breadth, since it generally includes all practical forms of paid work. It is not limited only to the industrial work, to which the designation of employment contract mostly refers. And in Germany, Philip Lotmar's two books on the employment contract reconstruct the development of a modern labor law based on the principle of the personality of work and attributing the same dignity to all contracts, including a work performance. Now the third argument, so please the next slide. Here, I would say that the great dichotomy between employment and self-employment has found a confirmation on the part of the neo-institutional economic analysis. The replacement of the classic market exchange with the contracts governed by the internal hierarchy entails advantages in organizational terms and in terms of reduction of renegotiation costs to adapt the relationship to the changing state of the world. However, these acquisitions of economic theory have undergone revisions and corrections also in relation to the changes that have taken place in the morphology of organizations. The legal and economic research of recent years has shown that in organizational context based on relational bargaining, market and hierarchy increasingly tend to hybridize. Within the relational model, the spot contract is replaced by a system of long-lasting relationships inspired by collaboration and trust, also governed by social and customary rules. These contractual forms indicate the different level of autonomy maintained by the parties, polarized between a maximum, the discrete transactions, a minimum, the hierarchical transactions, and an intermediate level, the hybrid transactions. In the light of these arguments, the economic thesis recognizes the dichotomy between market and hierarchy, and therefore between employment and self-employment, is no longer adequate. Hybrid forms of quasi-market and quasi-hierarchy are being used, offering the company a synthesis between the benefits and the costs of open market transactions and internal ownership. As Williamson writes, the study of contractual relations can no longer be limited to the examination of discrete markets and on the one hand, and of the hierarchical organization on the other, because the spectrum of exchange includes many forms ranging from pure market to hierarchy. So what Williamson calls the overcoming of the bimodal law of transactions in favor of a wider normal distribution corresponds for labor law to the overcoming of the standard polarization between self-employment and employment. And if it's possible to see the next slide, by adopting this analysis, this is, for instance, the Italian situation in this complex, much more complex scenario of hierarchy, market, and intermediate relationships. The comparative argument, so please the next slide. Well, the main result of the comparative analysis confirms not only the historical relativity of the great dichotomy between employment and self-employment in many European legal systems, but also the artificial nature of the model. In France, the choice of the criterion of the lien de subordination juridique, the subordination model, to the detriment of the doctrinal thesis on economic dependence, has not prevented the proliferation of extensive regulatory regimes, self-employed and even entrepreneurs, such as managers of branches, dealers, service station managers, franchises, and so on, are assimilated to employees with selective application of the Code du Travail, with no need to establish the existence of a lien of subordination. Albeit to a lesser extent, even in Germany, the category of employees-like person has been receiving a series of selective protections for some time, especially in terms of collective rights. Also in the United Kingdom, the grey dichotomy was overcome with the introduction of the notion of worker. Some basic protections are applied to this category of workers provided by the Employment Rights Acts and the Equality Acts, confirming the typically cumulative character assumed by the evolution of labor law over its long path. And I would say that English legislation has inspired other common law systems, even if they do not include intermediate categories, such as that of workers. For instance, in Australia, the Independent Contractor Act allows courts to assess the fairness of the remuneration of self-employed workers in order to establish if the contract provides for a lower remuneration than that paid to an employee performing a similar task, and the Fair Work section related to adverse actions suffered by self-employed workers concerns above all the prohibition of discrimination in the workplace, but on this basis the Australian doctrine proposes to extend the scope of the protection to all work relationships. This comparative analysis may continue. Let me say just that in Italy, by consolidating a trend to the extension of social rights, Italian labor law has moved towards the use of assimilation techniques to the point of widening the regulatory spectrum of the employment relationship without amending the definition of employee. The Foodora Riders case exemplifies this expansive trend of labor law very well through categories defined as intermediate or third. In conclusion, I have used the 4 arguments showing how self-employment is not to be considered a separate and alternative word to employment, but as a way of working for others in a personal way. In my opinion, thinking of taking this segment of the labor market into the area of subordination, perhaps on the simple assumption that it is bogus self-employment, or that the only category of work that deserves to be protected is dependent work, would be an error of method, condemning workers to be protected only as employees. Self-employment goes along with employment and is contaminated with it, and has the right to have adequate rights according to the needs of social protection expressed by people who are classified in categories other than subordination. So, first of all, it is necessary to recognize the union rights and collective bargaining for self-employment. An erroneous assimilation of self-employment within the category of the firm is denying these collective rights to self-employed workers on the assumption that the collective bargaining of self-employed violates European competition law. Second, fundamental social rights defined by the ILO conventions must be interpreted in a universalistic way, as the doctrine is starting to do. Third, the rights of social protection, income protection, training, and assistance in professional transitions must be extended to self-employment. And finally, the fundamental rights of the contractual work relationships must be recognized for self-employed workers. Working hours regulation, remuneration, protection of dignity and professionalism, withdrawal, are all aspects of self-employment that cannot be left to individual regulation among the parties. General protection against the abuse of economic dependence, as provided by the Italian legislator, is not enough. Specific subjective rights must also be granted to self-employment. The Italian legislator has followed this path with the law on a minimum standard for independent riders, even if, I have to say, the first choice of the law consists in attributing to these platform workers the status of hetero-organized workers with application of the entire spectrum of the employment law. So, labor law has a future ahead if it opens up to this unitary perspective, which is both universalistic and selective. On the contrary, labor law is inevitably going to be stuck in the mud if it will persist in the defense of subordination as the only of its paradigm. Thank you very much.
Thank you, Adalberto, for your splendid report. As usual, I would say inspired and inspiring, despite some technical problems. And now I leave the floor to Professor Tiziano TREU for the final remarks and for closing the conference. I greet you very warmly, hoping that the next international conference in memory of Marco Biagi will finally take place again in the foundation that bears his name, with all us present, healthy, and without mask. See you next year.
Thank you. Can you hear me?
Yes, very well, very well.
Well, how much time do I have? Because officially the session is closed.
I think 20 minutes.
Okay. No. I will try to concentrate my remarks. I've been really stimulated by many papers of this session, of all the sessions indeed. And I really congratulate with the organizer, because not only because of this good collection of papers, but also because really the initiative is timely. This has already been stressed. As we all know, labor law has devoted in the past most attention to subordinate dependent employment and absolutely under-evaluate the importance and the need of protection of self-employment. Now, as Adalberto mentioned, Marco Biagi was an exception, because 20 years ago, and I was with him, thought that it was already necessary to go beyond subordination and elaborate a set of rules which could be applied in different degrees to all kinds of employment. But at that time, the proposals were not accepted. Probably the times were not mature. Now, 20 years after that, we are really faced with a greater urgency to regulate in a consistent way the whole area of self-employment. And for this reason, this conference is absolutely important, because it fills a gap of knowledge. I only stress two reasons to motivate my declaration of the importance of self-employment. Is not the quantity of self-employment. In fact, the reporter before me has already indicated that the quantity has not grown in the many countries, but I stress the fact that within the general area of self-employment, the variety of conditions has increased. There is a polarization. The traditional individuals acting as artisans or in the small commerce have been really heavily hit by the crisis, and they have been reduced in number, while highly skilled professionals are growing and are acquiring strategic importance in the modern economy. So we have to consider not only the variety of works in this subordinate area, but also a similar differences in the area of self-employment, which makes for a further difficulty for policymakers. Well, I will not say anything about this gray area between subordination and independence, which has attracted a lot of attention by lawyers and legal scholars, also by the courts, and which has been discussed in many papers. I simply here want to mention a question which has already been hinted at by Adalberto Perulli. It seems to me that the controversies about the qualification, legal qualification of these types of work are going on, but in spite of this, there is a sort of remedial approach which is emerging, particularly among the court's decisions, but also in some kind of legislation. Remedial approach meaning that the decision has to do which kind of needs are there in this differentiated type of work, and we should give remedies to these needs regardless or even beyond the decision about which category they belong to. Well, I want to say a few words precisely about the evolution of the regulations in different countries of truly autonomous workers, as we can call them, to distinguish them from bogus self-employment. Well, there are at least 4 main areas in which the regulation about these workers, self-employed workers, have changed over time. First, welfare and social protection. Second, labor market regulations. Third, the traditional regulations of the individual employment contract. And finally, collective rights. Well, the evolution in the 20 years of these regulations in the different areas, the evolution is quite uneven. That is, we have trends differently developed in these different 4 areas. And of course, differences are also among the various legislation of the national states. So we have to look the complexity of these regulations, see how they combine them among themselves, if they are consistent, how they could be regulated and coordinated. Just a few remarks on each of one. Well, the first area in which the extension of traditional labor law to self-employment has developed is the area of welfare or social provision. Health care, of course, from the origins was applied beyond not only of the area of subordination, but also beyond the workers to grant basic benefits to the citizens. But old age provisions, pensions, have been evolving to extending many protections to self-employed workers. What is to be noticed? That the basic features of these old age pensions maintain a difference between the area of subordination and the area of self-employment. Difference in mainly the level of contributions, and consequently on the level of pensions and benefits. Most of these differences are hardly justifiable from a policy rationality point of view. And moreover, the very structure of pension systems has to meet the challenge of demography, the increase of life expectancy, the balance between old pensioners and young future beneficiaries of the system. So this is again an area of reform, necessary reforms, and meanwhile we will be called to discuss and suggest some kind of reform. We should keep in mind, if this is not the moment, also to rationalize the different regimes of the different kinds of self-employment, ranging from freelance to lawyers to professionals. These specific different regimes should probably be questioned. Second area has to do with the employment insurance. And I'm been very interested by the presentation by the Greek colleague from the Milano Polytechnic. Here, the protection of involuntary unemployment has been extended to most subordinate employees. Not all, indeed. It is not completely universal, not even this, because during the emergency, we have, not only in Italy, we have seen how many holes the net of protection has shown. But certainly the extension, the protection against unemployment has been very partially extended to different types of self-employment. The rationale being that the interruption of their activity is considered part of the entrepreneurial risk, and this is accepted by workers when they start their career. And our colleague showed the difference between the necessity-driven and opportunity-driven self-employment. This is a very interesting suggestion. We should think on that, because of course the risk of moral hazard is high in many of these areas, and probably the policy measures may not be indistinct and equal for all kinds of self-employed. But certainly the recurrent crisis of recent years has shown the fragility of many of these autonomous workers and falsified the assumption the lack of protection of most of these workers is socially not sustainable. In fact, some of the papers presented here have indicated national cases of legislation which have approved specific measures to regulate unemployment benefits. But certainly, the application of insurance scheme to these self-employed presents a series of critical issues. which should be considered and have been considered in the papers. One is the condition of access to these benefits. That is the gravity of the crisis, the loss of income by the workers, the duration in time, and again, probably the difference of attitude and experience of these kinds of workers. Certainly, the most critical issue is the financing of this system of protection. How to calculate the social contribution, how to distribute them among the parties. We have heard good suggestions in this respect. The double burden probably cannot be borne by many self-employed. There is high level of evasion of contributions, and this, in my view, raises a more general question that has become critical not only in this area, but also for other institutions of public welfare. That is, to what extent the support and welfare protection of these people can be financed only on the contribution of the parties, or instead has to be supplemented by some fiscal support, general fiscal support, or as our colleague said, to make the system less contributory, and I add more solidaristic, which is part of a broader question that is reducing the taxation on jobs. But this is a really critical issue which we should consider in depth. The second area has to do with the labor policies, because in the tradition of labor law, the development of welfare and support to workers' income in case of economic crisis has gone hand in hand in many countries with labor policies directed to activate the unemployed and also persons who are inactive. But these active policies, which are, by the way, uneven also in the subordinate area, have not been extended to autonomous workers. The assumption being more or less the same as mentioned above. But now the complexity of the markets and the increasing turbulence of them make more difficult to face the risks for many groups of self-employed, particularly those economically dependent. And that is consequently active policies and services tailored again along the needs of these self-employed might greatly benefit them. Of course, they have to be adapted to their conditions, and this is what has been done by recent Italian legislation, even though with rather weak provisions, but certainly, this is my point, providing full information about the employment opportunities, counseling of the various kind of persons, job search assistance is an important part of the future welfare. And on top, the professional training and education for these workers must be strongly implemented and accessible to all self-employed, even devoting to this fiscal incentives. Third area has to do with the regulation of contractual employment relations. The paper of Perulli indicates some lines of development here, and some of the new rules have been introduced by the Italian legislator in 2017, some of them extending to autonomous workers the basic rights granted to the employees, like protection in case of illness, maternity, work accidents, fair compensation, etc., etc. Other rules respond to different needs of self-employed workers, like the protection against the abuse of economic dependence, the recognition and protection of intellectual property. So this is an initial attempt to find new rules in the employment regulation of these workers, which I think should be watched carefully and extended to other countries and at the European level. Lastly, a few words on the collective bargaining practices. Of course, as we know, the legal regulation of employment in our countries has been implemented and improved by collective agreements. But this has not been the case for self-employed workers, even in countries where the right to organize and to bargain collectively is recognized. In fact, the objection which have been advanced in Europe by the European Court of Justice to the right of self-employed to bargain, with arguments that this should be forbidden by the principles of free competition, this argument has been criticized, widely criticized, and lately also by the European Commission, which intends to intervene in the matter in order to overcome the limits to this right of bargaining of independent workers. The point is that the actual practice of collective bargaining meets other obstacles, not the lack of the formal rights, but mainly in fact that the organization representing these workers are either weak or non-existent. And it remains to be seen if and to what extent the unions which represent the employees are willing and able to organize also independent workers. The first experience in many countries, including Italy, of bargaining for some categories of economically dependent workers, like the riders lately, shows how difficult it is to bargain and reach satisfactory results. Organizing these workers meet, in fact, structural obstacles, beginning with a variety of the conditions and needs of the individuals, which are quite different from those which have been considered by the trade unions in traditional industrial relations. But I think this is a major challenge which must be faced by the trade unions and by the groups of workers, independent workers themselves, particularly those most in need of collective action. Let me say a few words to conclude very rapidly. My remarks show the variety of questions, I think, which has to be considered and answered by those who think necessary, as Marco Biagi did, to provide adequate regulation and protection for workers in general, whether dependent or self-employed. Since the years of the first proposal of Marco, which wanted to establish a set of rules applicable beyond the borders of subordinate employers, some progress has been made by national legislators, by collective agreements, and by the courts, which have been called to decide disputes on these issues. And these rules, these interventions, however, looking back, are partial, diversified, and often not necessarily effective. Then I may think that probably the time has arrived to reconsider in a consistent vision and reshape all these materials of regulation to see how they match with the different activities emerging in the present and future economy and with the variable needs of their actors. The perspective, which is indicated by many papers and also by the official documents now of the European Union, the pillars of social rights, and also the recommendation of 2019, is, in my view, interesting. It is to the extent that labor law has to be reconsidered in a unitary perspective, which is both universalistic and selective, as Adalberto Perulli put it. But of course, it's not an easy task to reconcile universal guarantees and diversified protections according to the conditions of the various types of work. This is a major task for the future of our discipline, and it calls for research which requires, at the same time, rigor in the approach, but also open minds and creativity. This is our future challenge. Thank you very much.